Hey guys, welcome to Startup Sessions. My name's Abe Leachy, and today I want to talk to you about some trademark stuff. Specifically, likelihood of confusion office action refusals. If you got one of these refusals, you might be scratching your head wondering, what is this thing? What do I have to do to respond, and how much time do I have to respond? So basically, you get 6 months to respond to these non-final office action letters, and you could do that in the form of a response brief or in the argument section in the trademark forms. And essentially what it means is that the trademark examiner, the attorney who looks at your file, looked at your file and they thought that your mark was too similar to another mark that's been registered. And typically this means that your name or logo is too similar to the other mark, as well as the goods and services that you applied for being too similar to the other mark's goods and services. And to respond to this, you typically want to argue what's called the DuPont factors. So essentially you want to argue why the names are different or the logos are different. And that could be as micro as talking about the number of letters that are in the marks, the spelling or the sound of the marks, and if the mark has any meaning, either in a foreign language or otherwise, that would mean that the consumer is going to have a different impression. And then with respect to the goods and services, again, this is situational, but you want to be as detailed as possible to present the examiner with the why. Why are my goods and services different from the other mark that you're talking about? Other factors include talking about the channels of trade. So if the other mark is clearly a wholesaling type of brand that sells only through distribution companies to other businesses, and yours is just, for example, an e-com store where you're selling direct to consumer, that might be the type of channels of trade that you talk about. And then also, of course, to the consumers that you're selling to, and try to make the arguments that there's no way that a consumer encountering my company and my products is going to be confused with this other mark's company. Other factors could be if your mark is what's considered a diluted mark, which basically means that if there are a lot of marks on the register that are the same or similar in a bunch of different classes, it could be considered diluted, which means that it should be entitled to a narrower scope of protection. Basically, if those marks can coexist together and mine is not in direct conflict with any of them as far as the goods or services, then mine should be able to coexist as well. Lastly, and this isn't something that you can necessarily win on at the examining level stage, but if you see that your mark actually has been used in commerce since before the cited mark, if you're not successful in a response, sometimes you could leverage that to reach out to the owner of the other mark to say, hey, I've been using it since before you, and I could cancel your mark, but I'd prefer to just coexist, so sign a consent or a coexistence agreement and we could both go on our merry ways. That's obviously a decision that you would make, and if the situation allowed for it, but it's another option as a backup, because you do get one more bite at the apple if you respond to a non-final office action and you get another rejection. You'll get what's called a final office action typically, which gives you another 6 months to resolve that. So I hope you find this helpful. If you have any questions or comments, don't hesitate to reach out. You could drop me a comment below, shoot me a DM, an email, or give me a call. My number is 917-933-3895. Also, this is just for educational purposes, not giving legal advice. I kind of have to disclaim that, so hope you know that. Thanks a lot.